Today's episode is brought to you by Mazars.
SoundCartel.
People across Australia who've been sexually harassed at work can apply to the Fair Work Commission for an order to stop the sexual harassment. But this avenue wasn't an option until today. From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. The extension of the Fair Work Commission's jurisdiction in matters of sexual harassment is just one of the major changes from the Respect at Work Bill passed by the Australian Government in response to recommendations from a report conducted by the Sex Discrimination Commissioner. HR and industrial relations expert Cheryl-Anne Laird of Mazars says the bill is designed to help prevent sexual harassment at work. She explains the regulatory changes and what they mean to employers shortly. First, Cheryl-Anne tells Chris Ashmore what led to the Respect at Work inquiry.
Back in June of 2018, in recognition of the potential harm caused by sexual harassment in the workplace, the Sex Discrimination Commissioner Kate Jenkins and the then Minister for Women Kelly O'Dwyer announced a national inquiry into sexual harassment in Australian workplaces.
And what specifically did they look at?
The terms of reference for the inquiry was very broad. Essentially, it was a review and report on workplace sexual harassment in Australian workplace and also asked for recommendations to be made. The terms of reference specifically identified that recommendations were sought in relation to the prevalence, nature and reporting of sexual harassment in workplaces. What, if anything, is the role of technology in sexual harassment in workplaces? What are the drivers, including the risk factors for particular populations or in different workplaces? What are the existing measures to address sexual harassment and identify examples of where there is good practice? Identify the impacts on individuals and business, including economic impacts of sexual harassment in the workplace.
Well, before we go into what the inquiry found, what exactly is sexual harassment at work?
Sexual harassment at work is defined in the Sex Discrimination Act as a person sexually harasses another person if the person makes an unwelcome sexual advance or an unwelcome request for sexual favours to the person being harassed, or engages in other unwelcome conduct of a sexual nature in relation to the person being harassed. It has to occur in circumstances in which a reasonable person, having regard to all of the circumstances surrounding the events, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. And the sorts of things that are taken into consideration when considering those circumstances are things like the person's sex, age, sexual orientation, gender identity, and also the relationship between the person harassed and the person who made the advance or request, and also any disability of the person being harassed would also be taken into consideration.
How do we know then whether sexual harassment at work is actually sexual harassment?
That's a really good question because the legislation refers specifically to sexual harassment at work. And the Fair Work Act was recently varied to include a definition so that we can answer that specific question. And it is that a worker is sexually harassed at work if, while the worker is at work, one or more individuals sexually harasses the worker. So the connection is the person must be at work.
Well, turning back to the inquiry, in summary, what did it find?
Probably not surprisingly, because earlier reports had found similar things in terms of sexual harassment at work, but sexual harassment in Australian workplaces is widespread and pervasive. 1 in 3 people experience sexual harassment at work based on data between 2013 and 2018. 39% of women and 26% of men report having experienced sexual harassment in the workplace, again looking at that period 2013 to 2018. Aboriginal and Torres Strait Islander people were more likely to experience sexual harassment in the workplace than non-Indigenous people. It's not limited by industry, location or seniority in the employment setting. That is, it can happen to anyone in any workplace anywhere in Australia. The report found that sexual harassment is not a women's issue. It's a societal issue, and therefore everybody can contribute to addressing it. The harm caused by sexual harassment in the workplace is found to be financial, social, economic, emotional, physical, and or psychological. Sexual harassment in the workplace results in a very real financial impost to the economy through lost productivity, staff turnover, and associated impacts.
Are some groups more impacted than others?
They certainly are. As previously mentioned, there is certainly a gender issue with more women than men being impacted. The other groups that have been identified as more vulnerable are young workers, being people under 30, members of the LGBTIQI group, Aboriginal and Torres Strait Islanders, workers from culturally or linguistically diverse backgrounds, workers with disabilities, migrant workers or workers holding temporary visas, and workers in precarious or insecure employment, which would include that large group of employees who are casual employees.
And what did the inquiry recommend as solutions?
The report made a number of recommendations, all of which were accepted by the government in principle. However, only some of those recommendations have so far been implemented. The most significant of those recommendations which have now been implemented are those related to legal or statutory regulation of sexual harassment in the workplace. The inquiry found that the legal and statutory framework that was in place was no longer fit for purpose and recommended that a new model be implemented to improve coordination, consistency and clarity between the anti-discrimination legislation, employment legislation and work health and safety legislative schemes.
And what are those regulatory changes?
The most important, in my view, is the creation of a new capacity for the Fair Work Commission to extend its existing jurisdiction to make orders to prevent a worker being bullied at work, such that the Commission will be able to make orders to prevent sexual harassment at the workplace, or both if the person is making a complaint about both being bullied and sexually harassed at work.
Why is this an important change?
Although it's only one of many strategies which are needed to address this issue, it's an important one because it provides workers with easy access to an alternative than going to their employer directly to assist in the stopping of sexual harassment. Employees can make application directly to the Fair Work Commission. They're not required to go through their employer for a stop sexual harassment order. Such a jurisdiction might seem to be unnecessary to some people, but if you think back to that list of the people who are more vulnerable than others, it's a list of people who are perhaps not as confident to take their complaints directly to their employer without some sort of statutory framework which might also assist to protect their employment whilst making their complaint.
Do you think these changes will open it up to like a landslide of cases?
It's difficult to know. The jurisdiction doesn't commence until the 11th of November. When the Stop Bullying jurisdiction commenced, there was an anticipation that many cases would arise. However, that's not what actually happened. The jurisdiction for bullying has been an important avenue to support those workers who have accessed it. However, it's not been used as overwhelmingly as was initially predicted. Personally, I would anticipate that this extension of the jurisdiction to stop sexual harassment orders will be exactly the same, that there won't be a flood of cases through the door on the 11th of November or in the weeks following it, but there will be cases over time, and that the benefits will become clear for those who use the jurisdiction as time goes by. Importantly, it was my observation when we introduced the bullying jurisdiction into workplaces that many workplaces saw that as a key criteria for them to address from a policy framework which perhaps they hadn't before. And so although the jurisdiction itself didn't get inundated with people, as a consultant working in this area, it was my observation of our clients and of organisations generally that they picked up their game around workplace bullying, putting in place policies, putting in place mechanisms for people to deal with those things. And I'm hoping that this will be the same for this jurisdiction.
Is financial compensation something the Fair Work Commission can order?
Not for an application for a stop sexual harassment order. Like the bullying jurisdiction, the jurisdiction is not a jurisdiction of compensation. It is a jurisdiction of early intervention and seeking to put in place arrangements so that there won't be any future bullying or sexual harassment. It is not a jurisdiction which allows people to go and receive monetary compensation in any way.
Well, are there any other legislative changes?
Besides some statutory changes in terms of definition, the only other meaningful one that I can see is the confirmation that sexual harassment can be conduct amounting to a valid reason for dismissal, and formally expanding the definition of serious misconduct in the Fair Work Act to include sexual harassment. And although these two are really important changes, I do want to note that sexual harassment has always been grounds for termination of employment in specific circumstances. What it now does, though, is make that very clear to both those who may seek to engage in the conduct, but also employers who weren't really sure about what was open to them in terms of disciplinary action.
Well, finally, Cheryl-Anne, what's the ultimate aim of these changes and why should employers embrace them?
Ultimately, a safe and harassment-free workplace is also a productive workplace. Protecting employees from harm, although a noble pursuit in its own right, will also deliver financial benefits to organisations as well as improving culture and productivity.
That was head of the HR and IR division at Mazars, Cheryl-Anne Laird. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow @BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Mazars. To find out more, visit mazars.com.au. That's mazars.com.au.